There's entry. The jurors have returned. Please be seated. The court will recall People v. Nathan Woodyard, 21 CR 2794. Sergeant Smith's on the witness stand, still under oath. You may continue with your examination.
Thank you, Your Honor. Now, Officer Smith, when we left off before lunch, we just wrapped up that 2017 in custody death and excited delirium training. I'd like to talk now about another training related to some of those same issues. Could we please show just the witness, Exhibit 206, the 2016 Academy slides on in custody death and excited delirium? Officer Smith, do you recognize this document?
Yes,
What is it?
it's the PowerPoint for the excited delirium and in custody death for the training academy.
Okay, and is this a training that you put together?
Yes,
Is it a training that Mr. Woodyard received during his academy in 2016?
yes,
Does it appear to be a fair and accurate copy of those slides?
it does.
I'd move for admission of 206.
Questions or objections?
No objection.
Right, 206 may be admitted.
Then can we next show just to the witness Exhibit 207, please? And Officer Smith, is this a quiz that was given as part of the academy?
Yes.
Is this particularly a quiz that was given to Mr. Woodyard?
It just disappeared, sorry.
In the top left corner, does it indicate whose quiz this is?
Yes,
Is it Mr. Woodyard's quiz?
it is.
Does the academy keep these in the regular course of its business?
It does.
And are these quizzes put into the records by somebody at or around the time of the testing occurring?
Yes,
And does this appear to be a fair and accurate copy of Mr. Woodyard's quiz?
yes.
I'd move for admission of Exhibit 207.
Questions or objections?
Objection.
207 may be admitted.
All right, let's publish to the jury Exhibit 206. I don't want to spend too much time on this, Officer Smith, but is this training very similar to the training that was given during in-service?
Yes,
So let's go take a look at page 10. Is this basically the same slide that we saw before about positional and restraint asphyxia?
basically, yes.
Is that deliberate? Do you guys use repetition as a training tool?
Yes, it's also consistency in training. We don't teach incumbent officers something different that we teach basic officers.
Okay. Let's take a look at page 16 of this. Is this another one of those duplicative slides between the trainings about the myth of if you can talk, you can breathe?
Yes,
And on page 17, is this a repetition of that same story from Los Angeles about the individual who died after saying he can't breathe?
yes, it's the same slide.
Let's take a look at page 19. Are these repeat slides showing those indicators of signs of respiratory distress?
Yes,
Page 20, please. And is this a repeat of the slide we saw earlier about respiratory arrest being a medical emergency?
the top slide, yeah.
Thank you. Now, I would like to talk about the excited delirium section of this training, which does have a few different things in it. Let's talk about slide 26 first. Now, on the bottom, it talks about different medical conditions triggering a delirium event. What are you training officers about the difference between delirium versus excited delirium, the condition?
Well, the term excited is just an enhancer to the term delirium. It's just a version of delirium. We teach that there are different types of delirium. There's a hypo, a hyper, and a mixed. Hyper, exactly like it sounds, it's elevated, it's agitated, it's excited. Hypo would be something that's a little bit more catatonic, they're not responding in a way, and those are all types of delirium. Excited delirium is just a version of delirium where some particular behaviors that we encounter would include agitation, violent behavior, those types of things.
Okay, let's talk about page 27. Now, this top slide says delirium type events include and has a bunch of different things. Are you training people to be on the lookout for these different kinds of unusual behavior?
We're not training them to look out for those particular topics. The point of the slide is to teach the officers that the conception is that maybe it's just drugs that cause those things, and that's not the case. The slide is to point officers to there can be a lot of different underlying pre-existing conditions or acute symptoms that are causing it, but all of these things point to reinforcing that we need to look at the behaviors of the person to determine what we need to do in the situation.
Okay, let's take a look at page 28. What is this training about autism that you were giving?
So it's just a very, very brief introduction to a physical issue of autism in someone that can be experiencing a delirium type event. Can be like autism can be one of the underlying causes for that delirium type event, depending on what symptoms and the acuteness of whatever's going on. It's just we know that someone with autism can have delirium type events that we may come in contact with.
Are you also just teaching them about how to interact with people who have, neurodivergences like autism?
Not in this training. We are referring to other training on dealing with special populations that might dive deeper into that are taught by the mental health professionals. This is just referring to that training as hey, these also could be a cause for kind of an agitated event.
Okay. Could we go to slide 41 now, please? Is this again repeating the idea that not all resistance is a criminal action?
Yes, those are repeats of slides we saw before. I'm going to object to cumulative.
I'm done with the slide.
Okay. And that's pretty much what I was going to rule.
Now, I'd like to talk now about Exhibit 207, this quiz. Am I understanding correctly that this was a quiz Mr. Woodyard took way back in the foundational days in the academy?
Can we put it back up, please?
Sure, go ahead and publish Exhibit 207.
Yes. This would have been a written quiz in his academy time.
Okay. I'd first like to focus on this chart that's in the middle. In this quiz, does Mr. Woodyard correctly identify those different kinds of asphyxia that we just saw those repeated slides on?
You're going to make me check it as I go here. I'm assuming that since it wasn't marked incorrect, that those are marked correctly, but I can, if you want, double check.
Well, I guess let's focus on the answer he has for number 3, restraint asphyxia. Is that the correct identification?
It is.
Okay. And then let's talk about number 5, positional asphyxia. Is that the correct description, part B, body position interferes with respiration?
That's a correct answer.
Let's back this out. And you mentioned that the carotid training had to be passed 100%. It looks like this one got a 91% grade. Is this more typical of a lot of the other curriculum that you teach?
Compared to what?
is most of the curriculum that you teach able to be passed with a certain percentile grade that doesn't have to be 100%?
Like we discussed before, other curriculum can be passed at a 91%. This one would not be.
Okay. Let's take a look at question 7 here. Has Mr. Woodyard correctly identified that it's more difficult for somebody to breathe when they're in a prone position?
Yes.
Let's back out. Now, Officer Smith, over lunch, I was thinking about our conversation from this morning. And when I was asking you questions about training that officers have to communicate even a single complaint of breathing to the paramedics, you gave an answer, and please correct me if I'm mischaracterizing this in any way, but you said something along the lines of, well, if an officer was just in a long foot chase with somebody who then complains they can't breathe, that you would train them that isn't something they would need to communicate to paramedics? Am I remembering that conversation correctly, or can you correct me?
The example I was giving was a situation where an officer might have a person who says, I'm having trouble catching my breath or I'm having trouble breathing. And it doesn't necessitate calling rescue, 6 personnel, full complement and everything, because it's explainable. They were just in a foot chase. The officer's probably panting too. And we would look and see, and if the person recovered and everything went back to normal, you wouldn't need to do anything with that. So that was the example that was being used in that.
I mean, but isn't that judgment? Oh, I should take this person seriously when they say I can't breathe, but this other person I shouldn't take seriously. Isn't that exactly what you were explaining you trained them not to do?
That I trained them not to do? I
Yeah.
guess what are you referring to in that?
Don't you train them that every time somebody says, I can't breathe, that they should take that seriously and refer it for medical attention?
So this goes back to the question that we had before. The slide does not say they have to. I'd say that they have to do it at that first sign, but that it may be a indication of respiratory distress or respiratory arrest. And if it rises to that respiratory distress or respiratory arrest rises to the level of a medical emergency, then they would. But police officers every day have to make judgment calls on what isn't. And if it's a absolutely explainable cause that somebody is panting or having trouble catching their breath after a foot chase, and the person recovers in the time frame that seems very reasonable, we would not expect or train an officer to call rescue. If there was more to the story and they had more, I'm getting a hand here, so I'll stop.
Yeah, because you threw something in there. You said, and they recover. I'm talking about a single complaint where there is no recovery. Isn't the whole point of your training that officers aren't medical specialists, and that's why you call the medical specialists when there's even a single complaint of it?
Agreed, yes.
So specifically, you would want paramedics to be called as soon as there's any indicator of breathing problems, like somebody saying, hey, I'm having trouble breathing. You would want fire coming, rolling to that.
Let's be careful of the question again. Can you repeat it?
Yeah.
Because what we train them has qualifiers. It may, it can, right? So sometimes it can be an indicator, and that coupled with the fact that somebody is also displaying signs of that can also be indicators. But just one thing alone, there's nothing in the training that says you have to.
And I'm specifically focusing on the training. I
Yes.
don't want you to put on your, I'm going to be out in the hypothetical field hat. I just want to focus on the training here. Would you agree that as soon as a person says, I'm having trouble breathing, that you would train that you want rescue rolling to respond to that?
I'm going to answer the same way as before. If it is a known cause for that, I'm having trouble breathing, and we can give time for them to recover and they recover, I would not expect a call to rescue. If the person makes that complaint and then starts giving signs or starts, they start seeing these other signs, then I would. It's not, the training has to go to the general, like all of the general hypotheticals, not just one or the other. I feel like I'm answering the same way, and maybe I'm not getting to your question.
Well, Officer Smith, in addition to the prior recent testimony you talked about, you also gave sworn testimony related to this case back in 2021.
Yes,
Okay. And that testimony was under oath.
yes,
You were explaining to another group of people, somewhat similar to this one here, about the training that officers are given and what you expect of them.
yes.
Could we please show the witness his prior testimony from April 22nd, 2021, page 186, lines 17 to 20. Now, your answer in that prior testimony was, so the Aurora Fire, who are paramedics, we want them to call at any indicator of breathing. So as soon as a person says, hey, I'm having trouble breathing, we want rescue rolling. We can deal with the rest later. I read your prior testimony correctly, didn't I?
Yes.
Can we please publish to the jury Exhibit 205, page 27? This is that example that you use in training that comes out of LA about the person who says, I can't breathe. Is the point of your training to teach police officers not to discount when people say, I can't breathe?
Yes.
So let's go back to Exhibit 207, Mr. Woodyard's Criz, page 2, question 15. Does Mr. Woodyard here correctly answer that this is a false statement? If a subject who's in custody complains about breathing issues, the officer can decide if they need medical treatment.
Yes, that's correct.
And that's because this is not discretionary. The officer has to get the medics involved, right?
Sustain.
Is this a false statement because the medical determination needs to be made by paramedics?
Got caught up the double negatives. Is this a false statement? Sorry.
That's fair. Our officers trained that it's mandatory for them to have the medics make decisions about what to do about breathing complaints.
Yes.
That's all I have for you, Officer Smith. Thank you.
Cross-examination.
Good afternoon, sir.
Good afternoon.
Aaron, could we please have the screen? And Mr. McCrae, can we show the witness only exhibit, I guess, labeled as 202, but we'll label as defense exhibit? You see that, Sergeant Smith?
It's blank.
Oh, it's blank. Give it a second. Perfect. Is this a carotid control hold training that you've put together?
Yes.
And in preparation for today, are you able to tell us whether this was given to Mr. Woodyard as well?
Yes, it indicates that it was given to the class of 2016 2B.
Is this a fair and accurate representation of the training that you gave Mr. Woodyard? Or that was given to Mr. Woodyard?
Could you just flip through a couple of slides?
Of course. Please go ahead and scroll.
Thank you. Yes, it is.
At this point in time, defense would move to admit, and we'll call it Defendant's Exhibit A.
No objection, okay. Defense A will be admitted.
Thank you. Can we go ahead and publish Defendant's Exhibit A, please? And specifically, can we go to page 15 of Defendant's Exhibit A? Sergeant Smith, your officers are trained that when the carotid hold is properly applied, it is safe, correct?
We train that it's safe and effective in the general population when it's done the way they were trained and by professionally trained police officers.
Perfect. And in that training, this is a slide that you display to them. Is that
Yes.
fair? And in this slide, you back that up with a medical doctor's quote.
Correct.
Now, in this quote, it applies to a BVR, bilateral vascular restraint. Is that also known as the carotid?
It's another term for the same thing. So bilateral would be both sides, vascular, and then neck restraint is where that comes from.
So there seems to be some suggestion that officers know how risky this maneuver is, but what you're telling them is that when properly applied, it's effective and safe and can minimize injuries. Is that fair?
Yes.
Now, we also see that in this slide, you're teaching the officers this, that it's not only approved by the Aurora Police Department, but by a board-certified emergency medicine physician with the UCLA School of Medicine. Is that right?
I need to be careful of the question. What,
Oh,
could you
sorry.
say the question again?
Yeah, of course. I'm just referencing this slide. And what you're saying is that a board-certified emergency medicine physician is saying that when applied properly, it's effective and safe and can minimize injuries to the subject as well as the officer.
We are inferring from the quote that that is true.
And this is what was taught to Mr. Woodyard.
Yes.
And this is what was taught to all your, I guess, officers in 2016.
Yes.
And the way you teach it, you make it safer than what we would normally see in martial arts. Is that fair?
Yes, absolutely.
You require the officers not to put pressure on the back of the neck.
Yes.
In, I think you had mentioned MMA, jiu-jitsu, sometimes we see individuals put the subject in the carotid and also apply force in the back of the neck. Is that right?
That's correct.
Okay. But what the Aurora Police Department, through you, elected to do is to take that maneuver and make it safer.
Correct.
And you're aware that this maneuver, the carotid hold in jiu-jitsu, MMA, where they put the pressure on the back of the head, that's been around for a long time now.
Yes, the technique has been around for a long time. The putting pressure on the back of the head is a different technique, though. It's a neck crank. It's a pain issue that also the reason we don't want it to be done. So it's not normally a part of a vascular neck restraint, but it can be done in conjunction with, which is why we don't want it to do, just to clarify.
Thank you. I appreciate that clarification. My point being, Sergeant Smith, is when you're teaching officers this, you're electing to make this a safer maneuver than we often see in martial arts or jiu-jitsu or MMA.
Yes.
We can go ahead and turn that off now. I want to talk about these trainings. You also mentioned, or I guess you also train these officers on how to deal with situations where it's appropriate to use the carotid hold. Is that fair?
Yes.
You train your officers to deal with situations where they believe you train your officers how to react when they believe that a fellow officer's gun was grabbed, right?
All right. All right, go ahead.
Thank you, Judge. Now, I want to talk more about your trainings that you give to the officers, okay? And let's talk about them as a whole. I want to talk about the general philosophy emphasized in these trainings. There's been a lot of talk about checklists, 1, 2, 3, what's required, may, shall, should, okay? Understand the compound. I'll back that up. My point being is, one of the fundamentals that you emphasize on officer training is the officer's decision-making, correct?
Yes.
Critical thinking.
Yes.
Point being is, you are training human beings to be human beings, individuals who can think for themselves. Is that fair?
Yes.
You are not training individuals to be mechanical or robotic.
Correct.
You are not wanting officers on the scene to have essentially
That's the question.
Yeah,
We
sorry.
don't train. Sorry, let me ask. Or
No
can you
problem.
ask it
That
again?
was a very confusing question, my fault. Let me try that again. My point being is, with these trainings, you're emphasizing the officer to be able to utilize their training and decide for themselves what's appropriate,
Yes.
depending on the situation.
Yes, the situations are so diverse and different. We need critical thinking skills.
Obviously, in these trainings, you're not able to go through every possible scenario that an officer can encounter when on the field.
That's true.
If that was the case, we're talking about decades-long training. If I could sit and think of any hypothetical that you may not have a PowerPoint slide on, you'd have to create a whole new training.
True.
Essentially, what you're trying to convey with these PowerPoint trainings is not you have to do X, Y, and Z unless if there's the word shall.
Correct.
And what I mean by that is during your direct testimony, Mr. Slaughauer asked you a bunch of questions on slides that we saw, and you had kept emphasizing, well, it says may. Can you explain to us what the difference between may and shall means for a police officer?
So the language is very nuanced and it's important language though. Shall is a definitive. There's no qualifiers for it. That you shall do this. May, can, if practical, those open the door to the idea that every situation is going to be unique and different, and officers have to make those decisions in the moment with the best information they have, and do those. It's guiding principles, it's guiding statements, but where the department feels that it's very important that it's a you shall, you don't have a choice in this. If you take a police report, you shall write a report. That is a shall, right? But there's other times when qualifiers recognize the difference between rapidly evolving circumstances where that decision making may or may not be needed or employed by the officers, and we give the officers discretion, but we want to train them to use that discretion wisely.
Thank you. Now, you have been qualified by the Attorney General's office to be an expert in this situation. We've also heard in your direct testimony that you've had prior meetings with them. Is that fair?
Yes.
How many meetings would you say you've met or that you've had with the Attorney General's office?
Particular to this case, I don't recall. There were several.
Sure.
But
Let's
I don't.
say specific to the Elijah McClain matter.
Mm, a fair amount. I don't know what that number is. It was, I don't want to, I mean, it was, I don't want to guess,
Sure.
but there was a fair amount, several meetings over the course of the last few months.
Point being is we're not talking one or two.
Correct.
And you had informed them that it's the critical thinking component that is valuable in your trainings. Is that right? Let me rephrase. Is it the critical thinking component that's valuable in your training?
Overall,
Are you, So there's two questions in there, one that was referencing meetings that I had and one that was just overall training.
Yeah, let me just ask you this. It is the critical thinking component that is valuable in your trainings. Is that fair?
Yes,
You supervise a training unit for the Aurora Police Department.
yes,
You're a sergeant.
yes,
Are you a pulmonologist?
no,
Do you hold a medical degree?
I do not.
And just so we're clear, the Aurora Police Department also does not require 3-year officers to hold medical degrees. Is that fair?
That's fair.
We've heard testimony for the past week or so from medical doctors on these issues. Does the Aurora Police Department do the same for your officers? Do they bring in pulmonologists? Do they bring in coroners?
For these types of training?
Right.
No, we don't.
Well, let's talk about the trainings that your officers actually receive. Some people may have a tendency to think that an officer is an expert in every field, including the medical field. Is that accurate?
Some people would believe that.
Poorly worded question. Is it accurate that officers are experts in the medical field?
Is it accurate? No. Officers are not experts in the medical field usually.
Well, what about the thought that because they went through the police academy, certainly they must know more medical than most individuals?
I keep losing your, so you're
Sorry.
asking, does a person believe that that is true?
That is very poorly worded, and I apologize for that. I'm going to stop trying to confuse you. Let me ask you this. Is it fair to say that most of the trainings that the officers go through focus on enforcing the law and protection,
Yes,
okay, and protecting themselves?
yes,
These officers are taught to contact people who have actually been trained in the medical field to deal with medical issues. Is that fair?
yes.
Is it fair to say that the emphasis of the medical parts of the training that the Aurora Police Department employs is you are not a medical professional? Get the medical professionals out there to do their own assessment.
Yes,
The Aurora Police Department also emphasizes do not guess as to whether something or not is occurring. Get the people out there who are trained to assess this
if you need to, yes.
if you need to. Heaven forbid that the officer, with their lack of medical training, causes them to make the wrong diagnosis and leads them to take the wrong course of action, right? You don't want that liability.
We wouldn't want that liability.
You don't want an officer, let's say, taking a pen and performing a tracheotomy on an individual because they think they're struggling to breathe.
Correct.
The reality is these officers, they only receive basic first aid training.
Correct.
The reality is when we're talking basic first aid training, it's what anyone in a cubicle can get if they go to the first aid.
It's the same program. It's the Red Cross. It's a very same program taught by the same people. Yes.
The Red Cross building, similar to if a 13-year-old wants to go and get it, they get the same training as the officer.
I mean, I don't know if there's a program for 13-year-olds, so.
Fair enough. I was trying to stretch on that one.
Okay.
In these basic first aid trainings, we're talking like CPR, right?
Yes, the basic first aid deals with recognizing like a cardiac arrest, recognizing breathing issues, and then functionally teaches CPR.
And then it also teaches call 911 or get medical.
That's part of the process, yes.
Are officers expected to know how many heartbeats per minute is normal?
No,
Are they expected to know what, an irregular heartbeat looks like?
in the training that we do specifically in carotid, we address what a weak or irregular heart rate is in terms of the user level. I'm feeling this. This is the point when I need to use CPR, right? So that's also in the CPR curriculum. It's you can start CPR when it's a very, very weak or when it's noticeably irregular. And that would be kind of the limitation, but not much more than that.
Sure, basic levels is what I'm trying
Right.
to get at. Okay. You mentioned the carotid training, so let's turn our attention back to that, if you don't mind.
Yes, sir.
As I understand, the Aurora Police Department requires officers to attend the lecture for the carotid.
There is a lecture portion, yes.
We saw a bunch of slides during our direct with statements underneath. Are officers given those statements in the slides with the statements?
That depends on the class and kind of the time frame. Sometimes they do, sometimes they don't. In service versus basic. I mean, there are times when we give them the entire slide deck, and there's times when we only give it to them if they ask for it.
Can you tell us whether any of those slides with the words were given to Mr. Woodyard?
I can't from memory. I wouldn't, have a recollection of that.
Now, when I envision a lecture, I envision a teacher there with me sitting and listening very attentively, not browsing on my computer or anything.
I would hope.
Okay. Is this a similar situation where if a student has a question or an officer has a question, they can interact with the lecturer?
Yes, it's an in-person lecture.
And when I envision a lecture as well, and I see words there, is the lecturer just simply reading what's on there, or are they trying to communicate and elaborate and give examples?
So the way that we structure it is whatever's on the PowerPoint needs to be communicated. The information that's in the notes section for the instructor notes needs to be communicated. And as long as the instructor doesn't deviate from the intent and purpose of the curriculum, they can add experience or stories or become just an instructor that's engaging.
Certainly. Now, let's say there's an officer there that's just not quite understanding the concept. Are they allowed to engage with the lecturer and ask the questions?
Yes.
So they attend the lecture, then I understand it that they go to a gym with blue mats and they actually perform the maneuver. Is that fair?
Correct.
Now, I also understand that you've met with the Attorney General's office and gone over these lectures and trainings with them. Was that right?
Yes, the parts that they wanted to talk about, yes.
Understanding that we haven't attended any of these lectures, I want to ask you some questions about them, okay? Can we please put up slide People's Exhibit 200, Mr. McCrae? And then may I have you turn to page, it's 23. So it'd be 23 on the slide, but it'd be actually 19 stamped on the slide. That makes sense. May we publish, Your Honor?
Assuming I have to flip back at my charts, but this has been admitted presumably.
Yes, Your Honor.
200, okay.
Okay. You were asked questions about, I guess, in terms of this checklist, okay? Understanding that none of us actually attended the lecture, I want to talk about this checklist here. When you're asked questions about this, it was phrased in the test that they perform in the gym, the blue mats. You had kept saying, in the situation we present to the officers. Can you explain to us why there's a difference when Mr. Slothauer was asking you a question? You kept saying, well, it depends on the situation we present to the officers.
So the training lesson plan isn't just kind of one thing, it's multiple things. We have to test on different things. So the officers, after they're practicing, we work them through some of these scenarios. And one scenario was where the person gives up. We talked about that. So the officer has a partner. They demonstrate the proper technique. They demonstrate the verbal commands that we would expect them to say. The suspect is directed to, or the actor suspect is directed to show their hands. And then the officer has to show that they de-escalate, take pressure, get that prone control, cuff, and do everything from there. So that would be one scenario where it's just testing the proper alignment, the proper positioning, the orders that are given, and then the proper follow-ups and the de-escalation. So in that, we wouldn't be doing those techniques, right? We wouldn't go through that whole list. If we go into where the person is rendered unconscious, the instructor controls when the person goes unconscious and when the person regains consciousness in the simulation. The actors do not get rendered unconscious in training. That would, the officers that are being the subject, they don't get rendered unconscious. So we have the officers properly align, and then we say, okay, the subject is unconscious, and then the person gives some sort of sign that they are unconscious. Then we would want to see the officer do that. They go all the way through, and now this is where the person is still unconscious. They have not come to yet. We don't have any indication, so that's where we start that checklist. Check for vitals, check for breathing, call rescue, provide first aid if necessary. Then we say, okay, your person is now awake. What's the next step? And we need to make sure that they check for coherency, that you can answer questions and that you're doing that. And the person usually responds affirmatively to those questions. And then we have them, go through the administrative, show us your search, make sure you're covering everything that's systematic, sit them up, do this, and then make sure they go through the rest of the list.
So we stop you there.
Yeah,
Okay.
sorry.
In the questioning with Mr. Slothauer, he was asking questions about the test that you guys perform, and by you guys, APD. Okay. And there's a portion where you had said, well, there's a difference between the test and real world application. Do you remember that?
Yes.
And Mr. Slothauer then stopped you and said, no, only the test. We're only going to talk about the test. Again, you are training these officers to deal with real world scenarios, correct?
Yes.
In real world scenarios, you're not going to have an actor or a role player. Judge, I literally just was talking about his questions that he posed, but also he is an expert in the APD trainings and policies per their endorsement.
All right, the court will overrule the objection.
Thank you. And so understanding that you were cut off earlier to talk about real world application, that's what I want to focus on, right? Your trainings are to prepare the officers for real world application. Is that right?
Yes.
Because you know that in the real world, you don't have an actor that an instructor is able to tell them, stop fighting.
Correct.
You don't have an actor that a instructor is able to say, come in unarmed.
Correct.
You don't have an actor that the instructor is able to say, don't hurt this officer.
Correct.
And so in terms of this checklist here, that applies, I think you had mentioned when the subject is rendered unconscious. And so let me ask you, in terms of this checklist, if the subject is awake and communicating with the officer and saying his name, saying his purpose, answering questions, does the officer have to, does the officer then have to provide first aid?
Objection, Your Honor. Scope of direct. Scope of expertise. On the scope, disclose an expert. The defense provides no notice basis for these sorts of space.
Judge, in response, this isn't my expert. I don't have to provide, though he's their expert. They have to provide the disclosures. So,
All right, well, I'm going to sustain the objection in part, and that will be based in part upon the record I made upon an earlier question at the bench. So you need to rephrase.
certainly. So let me talk to you about this checklist and how that applies, okay? The check vital signs, breathing, and pulse. Does that need to occur if the subject is awake and communicating?
Objection. Also, in addition to what I just said, additional relevance. Officer Smith's subject of the should have.
Judge, if I may respond, I'm a little confused. This checklist was gone through all in direct, and now they want to prevent me from asking questions about how the checklist is actually applied and when it's not applicable?
I think we need to confine the questions to the specific training.
Let me ask about the training then. If a subject is awake and communicating, do they have to check the pulse?
Sustain.
Not talking about real world, talking about the training. And I understood you, and correct me if I'm wrong, in your direct, you had mentioned there's a difference between if the subject remains unconscious or if they're awake. Am I right on that?
Yes.
Okay. So in the scenario where the subject is awake and communicating in the training, do they need to check for breathing and a pulse?
We don't have a scenario that shows when the person is not actually, let me take that back. We do. The de-escalation scenario is a scenario where we applied the carotid and we did not render the person unconscious, and therefore they wouldn't need to go through the checklist in that case.
Are officers trained that if a subject is communicating, they have a pulse?
I think it's inferred from the training. I don't have a slide that says that, but if a person is living, breathing, moving, we can assume that they
We
have a
need to
pulse.
confine the testimony to what the training is.
Well, and understanding that whether there's a slide or not, I believe you had mentioned that there's communication as part of the training. Is that right? That there's a lecture, that there's a practicum where the officers are interacting with the instructor.
Yes.
And in that training as a whole, so not just limiting it to slides themselves, are officers trained to use their critical thinking?
It has been.
Okay, fair enough. Are the officers trained that if the individual is conscious and talking, they likely have a pulse?
Don't,
And it really has been asked and answered. The witness earlier said it could be inferred.
Okay,
So we need to move on.
I'm good with that. Thank you, Judge. Now, rescue is called regardless of whether they're awake or unconscious. Is that right?
that's correct.
Now, for purposes of the first aid training that the officers receive, when we're talking about the check vitals, that's really to determine whether the officers need to give CPR.
Correct.
You don't train your officers to give CPR to someone that is awake and talking to them.
I don't train CPR, so no.
They're calling for rescue regardless, so there's nothing more they can do other than CPR for these individuals.
Unless there's other things like bleeding or those kind of things, but correct. Yes, I agree with your statement.
Let's talk about coherency. There is no script for checking for coherency.
Correct.
Basically, they're just checking to make sure that the subject is conscious and coherent.
Correct, but we have them ask questions to demonstrate that they know how to do that.
And that's for the test, is just to demonstrate that they know how to do that. But the purpose of that is to check to see if this individual is conscious and coherent.
Correct.
Additionally, the officer doesn't have to ask questions if the person is volunteering and saying things that they understand are coherent.
That would be true.
So it's just more of an assessment of whether or not the person has truly come out of unconscious state and is with it, let's say.
Yes.
Now, during the training on the carotid hold, you teach your officers that a suspect will usually return to consciousness the same way they went out. Subject that is struggling or fighting. They'll usually wake up struggling or fighting.
Yes, not in those words exactly, but yes, that is what we teach. That is common in a lot of cases.
That's because, as you teach the officers, the subject often doesn't realize that they're rendered unconscious.
That's correct.
This is why you train your officers to move quickly once a suspect is unconscious.
Yes.
The whole point of the carotid is to render them unconscious to gain voluntary compliance or to gain compliance.
The whole point of the technique is to gain voluntary compliance or render them unconscious temporarily so that we can get that.
Thank you. So once the subject is unconscious, the officers are trained to put them into a prone position.
Correct.
The prone position is where the subject is on their stomach,
Correct.
face down.
Yes.
And while they're face down, the officers then attempt to control the arms and hands.
Yes.
So the point being is that they're trying to put the hands behind the back to handcuff them.
Yes.
This is what the Aurora Police Department trains their officers to do.
Yes. We have specific techniques in prone control to try and get control of the hands, to get them into a handcuffing position, and to place the handcuffs in that position.
And to Mr. Slothauer's point, if they fail to do this step, they fail the carotid training.
Correct.
You also train your officers that expect the subject to wake up right around this period of time when you're trying to apply the handcuffs.
We train that our practical experience is that most people regain consciousness in the process of handcuffing, and to expect that. So yes.
So you're teaching them to be ready in case the subject went out fighting, wakes up fighting as they're trying to handcuff them.
Correct.
Now, after handcuffing the suspect or subject in the prone position, you teach your officers then to put them in the recovery positions, right?
Correct.
Recovery position happens after the subject is on their stomachs and after they're placed on handcuffs.
Correct.
Now, because the subject may not realize that they even lost consciousness, you instruct your officers not to stand them up.
When that technique is applied, unless there's a safety reason to do so, we avoid having them stand up right away.
You just don't want them to fall down.
Correct.
Along those same lines, you teach
So no, that is, we take to avoid doing it standing up because there might be circumstances where that's absolutely necessary. But in most cases, we would want them to avoid, and we train them to do it from the ground.
fair enough. Thank you for pointing that out. That's one of those words that we hone in on, right?
It is.
Avoid, it does not mean the same thing as shall.
That's correct.
There is no ban on applying the carotid to a standing subject.
That's correct.
I want to talk to you a bit more about the recovery position. Um, May we publish Exhibit 178? Oh, actually, I'm sorry. May we approach, Judge?
Okay.
Um, You had been asked numerous questions on direct regarding slides involving the statement, "I can't breathe." Do you remember that?
Yes.
You had said that in terms of hearing "I can't breathe," the officer is expected to use the totality of the circumstances.
Yes.
It's not a situation where once those words are uttered, rescue absolutely has to be called unless the situation warrants it.
Correct.
So you gave the example of the foot chase. If a officer is chasing a subject and the subject is huffing and puffing and indicates they can't breathe, but after a while they indicate or no longer complain of that, You mentioned in your direct, that's a totality of circumstances judgment call.
Correct.
Again, what we're talking about are not robots, but human beings analyzing the situation in this specific situation.
I'll allow it, but I think everybody has the point about robots.
I like robots. Is that fair?
Yes.
Now, you're also in that line of questioning. Mr. Slothauer had noted to you that you testified previously about this whole subject matter of I can't breathe. Do you remember that?
Yes.
He had talked to you about the fact that you were just here a few weeks ago testifying in front of a different jury about that. Do you remember that?
Yes.
You were asked a number of questions of these questions related to other officers in that scenario, correct?
Yes.
Not about this officer. I'm sorry.
Was there a question?
Yes. Is that a yes or no? You were not asked about this officer.
Yes.
Let's talk about the term change the situation. Is that a term you use?
Sustain.
Sorry, I'm asking about his experience if he uses that word.
Sustain.
Let's talk about de-escalation. The carotid, depending on the circumstances, can be a de-escalation technique. Is that right? Do you train it to be?
Yeah, I'll allow it
Thank you.
based upon the phraseology in that question.
Depending on the situation the officer is facing, do you train the carotid to be a de-escalation technique to avoid higher uses of force?
This goes to the two prongs of de-escalation that we talked about earlier. One, once I use force and it's effective, I have to de-escalate that level of force. And then the other one is reducing the intensity of a situation. Now, the point of de-escalation training isn't to like teach officers to use less force so that they don't have to use higher force, but that might be the case. So de-escalation is a result. It's what occurs if everybody's open to the influence of whatever tools or tactics and that we use. At times, a lesser force can be a tool to get the situation under control so that we don't have to use more and higher levels of force later. So in that way, yes, but I don't know that I'm comfortable saying that this is a tool that we teach as de-escalation because we don't teach that of any tool. We teach the tool that use the tool that's appropriate when it's reasonable to do so and it's necessary to do so in those cases.
Fair enough. Can we please publish, well, excuse me, I'll hold off on that. My point is if there are tools available to the officer, let's say weapons, right? A gun, a baton, or something along those lines. The carotid could be a way to resolve the conflict quickly and with less injury than, say, a gun.
Yes.
Now, de-escalation, though, also does not override officer safety. Is that right?
Correct.
De-escalation tactics should be used only once an officer feels safe to do so. Is that fair?
When it's practical to use those techniques, that's when we train the officers to do that, keeping in mind their safety, the safety of others, and even the subject safety. So it's not all inclusive to one perspective.
Fair enough. I think I see you kind of thinking through and trying to answer your question. I think, is that because there's no one size fits all scenario.
Yes, and we are getting into like, I just want to make sure the words I'm getting are not getting confused. So yeah, so that if I pause, I apologize. I mean, but that's, I'm wanting to make sure I understand the question, and then yes, also because it's not one size fits all. I want to make sure that I'm thoughtful about the response.
Sure. No need to apologize to me.
Oh, okay.
But you keep using the term when practicable, and I want to hone in on that. Point being is, as we just mentioned, there's just unforeseen circumstances the officer has to take into consideration when facing scenarios. Is that fair?
That's correct.
And you keep using the term when practicable because your trainings take into account that these officers are being sent into unsafe scenarios. Is that fair?
Yes,
And you don't want to give an answer that encompasses, or I guess, encompasses all possible scenarios.
that's correct.
There's always an exception to, I guess, when we're talking about de-escalation, right?
Yes.
Try to use de-escalation, but I guess you can think of a scenario where de-escalation would probably not be the wise choice.
Sustained. Need to kind of stick to the training.
All right. Can we then please put up Exhibit 216? And it'd be page 46. Do you teach these officers that if you're attempting to de-escalate a situation, it's also dependent on the person you're interacting with?
Yes.
Because you can't always account for how that person's going to react.
They get a say in the situation.
We're talking about when you're saying the term when practicable, it means that you can't use a one size fits all scenario, right? Can we turn to page 12, please? There's that term when practicable. And is that one of the reasons why I keep reemphasizing that term?
Yes.
It is literally in your training that de-escalation when the subject is receptive to verbal communication.
Yes.
And your training also on de-escalation also takes into consideration that force was used. And so when force is used and successful and they've gained compliance, then de-escalation can occur. Sorry, that was a lot. Your training also contemplates the fact that use of force sometimes has to be used. And so that last bullet point there, what you're saying is after the force has been used and is successful, and the officer has gained compliance from the subject, then we can start talking about de-escalation.
I think that that last point is like the second prong, that we don't continue to use force after it's been effective or it's no longer reasonable or appropriate. So more specifically, it's not after force, I use de-escalation. That's referring to the idea that when the force is successful and I'm getting compliance, I don't continue to use force. So a little bit of a difference.
Sure. Now let's talk about, moving on, thank you. Let's talk about trainings for the officers when you're dealing with use of force situations. These types of trainings that you went through with Mr. Slaughauer. Not going to use the R word, but or I guess I was going to say robot. You take into account the fact that your officers are human beings.
Yes, we do.
Okay. And so you understand that human beings have limitations,
Yes.
emotional limitations,
Yes.
physical limitations.
That's in the training.
Okay. These are all things you train on.
Yes.
The training you had, it was to allow other officers, if one officer is exhausted, to allow them to take control. or excuse me, that was poorly phrased. If one officer is exhausted, other officers you train to allow them to take control. This is, I used the word training in the question, Judge.
All right, perhaps you could focus on which training, then we can go from there.
Okay. Are there trainings where it's considered that if the officer has reached their physical limitation, others take control?
Sustain.
Are there trainings that you're aware of that Mr. Woodyard has gone through that allows other officers to take control when one is gassed?
Yes, in his basic curriculum, that PowerPoint includes slides about officer relief and other situations.
So in the training itself, the officers are told or taught that if you are gassed or if you've reached your physical or emotional limitations, it's okay to let other officers take over
Yes,
to prevent mistakes from occurring.
those words are not in the training, but that's the intent.
Again, we're talking about the critical thinking piece, right?
Yes,
Understanding these officers can be in dangerous situations, right?
yes,
You want officers at their best addressing those dangerous situations, right? Is that what the training teaches or focuses on?
I'm sorry, I lost the question.
No problem.
Yeah, I'll sustain the objection, rephrase.
Is your training focused on having officers at their best addressing dangerous situations?
Sustain.
Are your trainings that Mr. Woodyard went through teaching officers that you want them at their best when addressing dangerous situations?
Sustain.
Okay. Point being, is the training that we were just referring to, I think you had said it was a basic training,
You specifically referred to training that Mr. Woodyard took,
right?
and that would have been in his basic training. There are slides in that basic curriculum for ACT.
And the basic training gives concessions for someone who is mentally and physically recovering. Is that fair?
It was asked and answered.
Point being is in the basic training that Officer Woodyard went through, officers are allowed to rely on others to help out. Judge, I'm trying to get a question out here.
Yeah, and it has been asked and answered.
Okay, well, I must have been lost in that in terms of all the questions and the objections. Is the answer to that yes? I mean, because I'll move on if I just need to know that answer.
Yes, it was.
Okay. Understanding that apparently we can't really get into that much more. Okay, I'll move on. Now, it appears that your training heavily emphasizes on getting medical to scene. Is that fair?
Yes,
We've heard a bunch that Aurora Fire and Rescue is who the Aurora Police Department contacts for medical assistance.
correct.
And when Aurora Fire, you teach your officers, when Aurora Fire meets them, they bring their firefighters who are also trained paramedics.
Some are.
That's pretty much your equivalent, when I say your, APD's equivalent of calling 911 and asking for medical help. Is this what you train your officers?
That rephrase.
Is this what you train your officers at? Is this equivalent?
Rephrase.
Okay. In your trainings, in your training to Mr. Woodyard, that Mr. Woodyard went through, this is essentially the same as calling for 911 for medical help.
It is us calling our 911 communication center to get AFR on scene, who is the on scene medical authorities.
Now, when medical arrives, I believe you have been talking to Mr. Slothauer and talking about a hard line at that point, right? Do you recall that?
In reference to the graphic that's used to describe like the phases of, what's to be done.
Now, when medical arrives, the hard line is that medical takes medical control of that person.
Yes,
The hard line is that the officers have nothing to do with medical decisions. Fire has to do with the medical decisions. This is what he was saying in direct.
I'll allow it. And it's referring specifically to the circular exhibit that was shown. All right. Yeah, why don't we focus in on what the testimony will be referring to?
You train your officers that when medical arrives, fire, it takes medical control.
yes,
Do you train your officers that when fire takes control, they are taking control of all medical decisions?
yes,
They're talking a bit about that wheel, and I'll get to it in a second. Do you train your officers to intervene and replace their basic first aid knowledge with the medical professionals? I'm asking them about the training.
I think. All right. Well, why don't you rephrase?
So in terms of the wheel that we're talking about, you're talking about with Mr. Slothauer, where you're talking about drawing the hard line.
yes, sir.
Do you train your officers in that scenario to use their basic first aid training to override fires, paramedic training?
No, we do not.
Can I have one second?
Yes.
Now, to be clear, in your trainings, you teach your officers that it is not their role to decide what medication to give. Not true. I'm going specifically to the medication.
Well, really what we're getting, I think the witnesses testified 2 or 3 times now that the medical personnel are in total control, and getting down to the granular level is really cumulative.
Yep, fair enough. Can we please pull up Exhibit 205? And can we go down to page 67? So this is the wheel that you talked about, right?
Yes.
Now, and I apologize, our copy, we weren't given a color copy. Can we turn to page 72? You had been shown this and asked a lot of questions about fire protocol. And you had kept saying that the hard line was before sedation, right? You call medical, they do their own thing.
Correct.
That officers are not supposed to interfere with medical's decision-making.
Correct.
You were shown this which again, in our copy, maybe not the best quality, but if you can zoom in, Mr. McCray, on that left document, top right corner, is that Aurora Fire Department's protocols?
Yes, it is.
Are you required to know all of Aurora Fire Department's protocols?
No,
Do you teach and train your officers that they have to know all of Aurora Fire Department's protocols?
we do not.
Is this more of a demonstrative to explain to them, look, once fire gets on scene, they do their own protocols, they're in charge.
That's correct.
Get out of their way. Right?
Don't say those words, but that's what we want them to do.
Now, one thing that Mr. Slothauer noted was on number 6 in that. You had spent a lot of time with him asking you questions about Aurora Fire's protocols. Drawing your attention to number 6, is there anything on there that says anything about 500 milligrams of ketamine? Speculation. You can use size.
All right, well, it's fairly obvious. An answer.
Thank you, Judge. So I guess in my question to you, this is the slide that was given to Mr. Woodyard in his class, right?
That's correct.
Okay. And Mr. Slothauer had a ton of questions for you about, well, this is what they're shown, this is what they know, right? Do you remember that line of questioning?
Yes, I do remember.
This is what they're shown. This is what they were supposedly aware of, right?
Yes, we talked about that.
I want to show you another exhibit that you've been asked a lot of questions about. Can we go to exhibit 200? Maybe document page number 26, but actual 21. You have been focused in on this, and Mr. Slothauer had gone through all the steps with you. Do you remember that?
Yes,
Sure, you remember it better than most, but he had gone through step 1, step 2, step 3, right?
yes.
Did he ever ask you anything about step 9?
I don't recall specifically.
Step 9, as soon as rescue arrives, they will become the primary caregiver. Is that right?
That's what it says.
In your trainings, you are telling officers that step 9, get medical out there. And once they're there, they become primary.
That's correct.
The last thing I want to ask you, can we pull up exhibit A, please? And can we go to page 8, or excuse me, page 15? In the beginning of my questioning, I showed you the slide. Do you remember that?
Yes,
And I talked about that first phrase, when properly applied, right? Do you remember that? Can we turn to page 8, please? This is a picture that you show in that training of a cartoon drawing of the human neck, right?
yeah, it's an image of an anatomy.
And you're showing them, or showing the officers, the areas you need to avoid damaging. Is that right?
We show the areas that we are intentionally trying to put pressure on, and then we show the areas that we're trying to avoid.
And you had also been shown page 9. Can we go to 9? Damage to hyoid bone, cartilage, thyroid cartilage, right?
That's correct.
And so when you're talking about when properly applied, you also want to avoid damage to those areas, right?
That's correct.
You don't want to cause any breaks or anything along those lines.
That's correct.
Those types of breaks could be revealed in a coroner. They would notice any damages to there.
We would believe so.
And so when properly applied, there would be no damage to those bones, cartilages, correct?
Yes.
Thank you. If I could have 1 second.
Yes.
You have been asked in terms of one of the trainings of an individual who was in custody, Jorge Azucena. Do you remember that? Where LA,
Yes,
he had been left face down. Do you remember that?
I remember referencing that in direct.
Um, In that scenario, was fire ever called? Do you know?
In real life?
Right.
I do not know the answer to that.
Well, that's what we're trying to get to, but I think he answered the question on that. So I'll move on.
All right, so I'll sustain the objection.
The last thing, if we could have the screen again, I'm going to be showing you Exhibit A, page 5. Officers are taught that when the carotid is applied, there's still a vein that runs to the brain in the back, correct? Back of the head.
That's correct.
Okay. And so it doesn't cut off all blood to the brain. Is that fair?
That's the language that's in the training, yes.
Thank you. Those are all my questions. Thank you, sir.
Redirect.
Officer Smith, when we're agreeing with the defense attorney's questions a minute ago, one of them they asked you was whether once the paramedics show up at the scene, you train officers to get out of their way. And you said something along the lines of the training doesn't use those words, but yes, that's the idea. Is that accurate?
We don't use the words that were stated in the question, but the principle of they are the primary people responsible is true.
Sure, but that's very different from getting out of their way, isn't it?
Getting out of their way is a very broad hyperbole. So that's why I disagreed with the statement.
Well, right, because there are a lot of ways that you train the officers they need to be involved once the paramedics are there. Isn't that fair?
Correct.
For example, they may need to restrain a person even after the paramedics are there.
Question, Judge. Leading?
Oh, all right, rephrase.
Do you train officers that sometimes they will need to restrain somebody after the paramedics arrive?
Yes.
Do you train officers that they need to provide information to the paramedics about what happened before the paramedics got there?
They can provide information they believe is relevant. Yes. Your question was that they, now I've lost the question. It seemed like your question was specific to, yes, they have to do a certain thing. And we're kind of getting back to those things. Could you re-ask that?
Sure. Do you train officers that it's the best practice to provide information to the paramedics about what happened before they got there?
If there's time to do so and they can and it's relevant, yes.
Yeah. So relevant medical information,
Yes.
relevant things that happened to the person.
Leading?
Response.
I'll ask it a different way.
Okay.
Can you describe to the jury some of that relevant information that you would train officers as best practices to tell the paramedics?
Relevancy is the key term. It can be very different in every different situation. It depends on what is evident when they're on scene. I don't have to restate something that they can see. I don't have to retell them something that they can hear once they are on scene. And then it's kind of up to the officer to determine like what is those points, what they're capable of and what they're doing. Sometimes there's time, sometimes there's opportunity to do that. Other times there isn't. So that's where it's like it's all very relative to the situation. We would expect some communication of, what they're dealing with, and if that communication hadn't already occurred on the radio.
So do you train officers that the things they witnessed before the paramedics get there, they may be the only source of information about?
Speculative.
Response.
I asked if you train them that way or not.
if you could refer to a specific training, I think it might be helpful.
Sure. Well, when the defense was asking you about where you trained them to get out of their way when paramedics were getting in the way, showed up, what training were you referring to there?
I believe that he was referencing the slide in that .9 about how medical is the primary on that.
On the carotid training?
I believe we were on the carotid training when that slide was there.
Republished for the witness, Exhibit 200, page 19. This one?
Yes.
Are we talking about that last paragraph? Or excuse me, the last, oh yeah, this is perfect. Last paragraph down here.
I think that's what you're referring to in your question, yes?
Sure. So
Okay.
you train them, they are supposed to involve, do you train them that they are supposed to inform the paramedics about things that happened before they got there, like the violent resisting nature, consciousness, things like that?
Overall,
That how you
Yes.
train them? Now, you made some statements on cross about how the carotid is safe in general population when done properly. I want to unpack that term, done properly. Does that mean that it has to be applied properly?
Yes.
Does that mean that it has to be released properly?
Yes.
Does it also mean that you have to do the proper follow-ups?
Yes.
When you said on cross-examination that some of the things that you teach are designed to make the carotid safer than in martial arts, are you talking about just about the way it is applied?
Yes. The way that it's applied and its association with other techniques that are similar.
Okay. Would you agree that MMA sport carotids have a very different situation after the carotid is applied than what police officers encounter in the field?
Yes.
So, for example, is there a referee peering down at the mat when you're out?
Outside the scope.
And Your Honor, I think it's just fair follow-up on the defense induction of the testimony that's safer than an MMA.
yeah, sounds like closing argument, sustained.
Now, the defense asked you a few questions about critical thinking by officers. And you were agreeing that, we teach them to be humans and not just robots. Do you train them that they should follow their training?
Yes.
Do you train them that they have to follow APD directives and policies?
Yes.
And that it's mandatory to take those things into account as they're doing their critical thinking?
Yes.
The defense asked you about meetings that you've had with members of our office here. Did you also meet with the defense?
I did.
Can you tell me how many times?
I believe one meeting, maybe. There was one meeting and then I think there was a follow-up phone call or team, so maybe two. I don't recall exactly the number, but it was a couple of times.
Okay. Do you remember about how many hours?
I believe
I-
they objected to me in terms of getting to the depths of this. Sorry, I'm gonna object. It's the same objection the people had when I was going down this route.
Response.
And Judge, my only objection was to what he might have said to us as hearsay, not about the scope. And so I think this just goes to credibility and bias.
All right. Well, the court will allow this question as to the length.
You remember about how many hours?
I believe it was maybe right at 2 hours. The one meeting that I can recall, I think there was another quick phone Teams meeting that was a few minutes. But that's all I can recall right now. I'd have to look at my schedule.
Okay. Because they asked you about training about an officer being gassed and being replaced. And you said that there was training on that and there were slides. What training are those slides in?
So in the basic curriculum that was offered as an exhibit that is in that curriculum, there's a whole series on the limitations of officers, things that officers have to understand in terms of their emotions by their physicals, what they have tools available to them, size, strength, ability. And so there's a series of slides in there that arrest is an emotional problem as well as a physical one. And so I wasn't specifically referring to any particular slide, but there are slides that talk about the limitations that officers face and how things are different when they are by themselves versus with someone else, when they have tools, when they don't have tools.
Okay. The defense asked you a couple of other questions about Exhibit 200, page 19. Could we throw that back up again? One of the things that you started to say was that you in training don't have a scenario for when the person is breathing and awake, but then you took it back and you said that you did have that scenario. Where is the slide that says you train officers that it's okay to skip the checking vitals stage?
I mean, there isn't a slide that says those words.
Now, you testified, you can take that down, on cross that an officer is supposed to use the totality of circumstances to determine whether they need to do anything about a subject complaining they can't breathe. Is that accurate?
Yes, I did say that.
So are you saying that there are circumstances that they could do nothing with that information?
We gave examples of the extremes when someone is obviously having a medical issue and making that complaint. And then we said the extreme of someone who has a issue that is completely like contributory, right? So that like you were just in a foot chase, you're going to be short of breath. You might say, I'm having trouble catching my breath. Let's give you a couple minutes and do it. So we talked about the two extremes of that and how there is critical thinking between those two extremes. We didn't discuss everything in between.
Well, even if there's an obvious cause, though, for somebody saying, I can't breathe, do you train them that that means that it's not a medical emergency?
Section Judge, getting to hypotheticals, which I believe he objected to.
Response.
I'm following up on what the defense introduced about this totality of the circumstances and comparing it to the actual training slides.
With improper hypotheticals, which he objected to.
All right, well, I'll allow inquiry, but we'd stay away from specific hypotheticals.
So do you train that even if there's an obvious reason somebody might be saying that they're short of breath, that they can just, that means it's not a medical emergency?
Section Judge, hypothetical.
Overruled.
We train that a complaint of breathing may be a sign that there's a problem. Among other signs, and that the officers need to look at those and see those, and to make a determine if it's a medical emergency. The slides say that if it is respiratory distress or respiratory arrest, that it is a medical emergency. We're guiding that decision-making process.
Okay. Every complaint of somebody saying I can't breathe, you train they need to treat as a real, honest complaint.
Yes.
We show the witness Exhibit 205, page 30. Do you train them that any complaint regarding the ability to breathe is a potential sign of respiratory failure?
Section Judge, asked and answered, cumulative.
Just following up on cross.
All right, I'll allow this question.
Do you train that any complaint regarding the ability to breathe is a sign or symptom of respiratory failure?
No, we teach that any complaint regarding the ability to breathe may be a sign and symptoms of respiratory failure.
Okay. Now, this slide doesn't say, unless in the totality of circumstances, I decide that this isn't important, does it?
This slide does not say that.
That's all I have for you, officer. Thank you.
May the witness be excused. Right, you may step down. Thank you. Counsel can approach, please. All right, members of the jury, we're going to take our mid-afternoon recess at this time. Refrain from forming or expressing any opinions, discussing the case amongst yourselves or anybody. Avoid any independent research as well as any media coverage. And we'd like to have you back here in around 15 minutes, please. Jurors have stepped out. We'll be in recess for 15 minutes. Court will recall People v. Woodyard, 21 CR 2794. Understand there's something that needs to be addressed.
Just briefly, Your Honor, I thought
Okay.
it would be better and quicker to do it without the jury presence. Deputy Chief Redfern is next. We're going to go through a couple directives. I have the directives not redacted, and I have directives that are redacted. I redacted one of the directives, which is use of physical force, by taking out the statute, because once again, that's the law. So I thought the court would appreciate that, but I actually don't have any preference. So I have a redacted version, a non-redacted version. The other one is less lethal devices, and I redacted a portion that talks about that the officers can go when they're asking for special consideration for things that are not standard. And so I redacted those sections also because I just didn't think they were relevant for the jury's considerations. It's all the procedures for proving less lethal weapons for use. So I showed them to counsel. He's objecting to these redactions. So we thought it might be easier to have a cut discussion outside the presence of the jury.
Okay.
Yes, that's accurate, Judge. One of the, I think it was the use of force one that Ms. Joyce was referencing, explains to the officers self-defense and when they're allowed to defend themselves, et cetera. I apologize, I'm going off of my memory, so thank you so much. It talks about defense of physical force in defense of a person, et cetera. So here's sort of the issue is just like what we had finished with Sergeant Smith. What we're talking about is what the officers were aware of, not that this is the accurate law. And so when we're looking at previous slides, exhibits 200, 204, 206, 207, they are filled with case laws. We've also heard there's Graham v. Forget what the other, Connor, thank you very much. Yes, there's a lot of law that's in the statement, that's in the exhibits that have been presented to the jury already. What's at issue is what the officers are taught and aware of. And so I'd be objecting to redacting the law that they don't want the jurors to see. But, I think in the interest of fairness, it should, if we're talking about things that the officers were aware of, that should be it.
Well, the court, I'm fine with keeping that in. The court will be happy to give a contemporaneous instruction that it's the court that gives the law to the jury that they must follow, not what's in the slide.
That's fine, Judge. That's why I redacted, because
Yeah, the only thing that I was concerned about based upon our earlier discussions was I do recall during Commander Redfern's testimony in the first trial about some of the slides had references to reasonable suspicion and things of that nature, which quite frankly, I was more concerned about redactions of those than what you just mentioned.
So two things. I actually do have a question about that, but I guess I didn't understand the court's ruling. Is it the redacted portions coming in or the unredacted portions?
Oh, unredacted.
Oh, thank you.
Yeah, and I'll give a contemporaneous instruction that,
Okay.
that this is to illustrate what the officers were instructed. We'll give the law that the jury must follow.
And then the other one was what the court just touched on. I don't know honestly, I don't know what directives I'm going to be introducing through Sergeant Redfern, but out of abundance of caution, I've been looking at what the court's previous order was regarding 8.32. And I see the portions that's talking about reasonable suspicion, et cetera. So I'm a little unclear in terms of how the court would prefer to handle this document. I can approach it with it.
Well, it really wasn't the document as much as it was the testimony of Commander Redfern. Because the positions of the parties had not apparently solidified at that particular point in time when Commander Redfern was testifying. There was some focus based upon the prosecution's questions on, and I'm paraphrasing, but Commander Redford said something to the effect that just because you received a call, you don't have to stop somebody, or you're not required to stop somebody. And then on cross-examination, counsel for, was it, Officer Odema went into a long cross-examination, kind of talking about those things. I'll let the people kind of get back into it afterwards based upon that. And I instructed the jury. So that's kind of my concern. That's the Gestalt view, I guess, if you will.
And I'm not saying that I intend to admit this. I just wanted to talk about for outside the presence of the jury in the event I need to decide what is being admitted. May I approach this so I can get the court's view in terms of what needs to be redacted, whether this is appropriately redacted or needs more redaction based off past court order?
And Judge, I'm just gonna say that I think the bias-based directive should not come in, because once it's redacted, there's so much redacted that it's gonna leave the jury to speculate, and it's a sort of the rule of completeness also, and it's gonna be confusing to the jury about what the missing words and what they are. So I think confusion of the issues, people are not getting into that directive. and
So you're not going to be talking about 832 or whatever it is.
Correct.
Okay.
But I just need to know if I'm going to be, and so what it looks like in case I do. I just need to know sort of the direction before I head down that road.
Well, it's the heading down the road part that I can't speculate about. If you head down the road in a certain direction or a certain speed, it might all become relevant, including the title.
Sure. The way I view it, just to make a record, is I've attempted to make a redaction based off the prior court's ruling. We had the hearing, or I guess the issue addressed pre-trial as well. And so I've redacted it in that sense, but I just don't know if it's.
You know what the problem is, and I think it was fairly well articulated by Ms. Joyce, is when we have a document that has a bunch of redactions or black spaces in it, it does, there's plenty of case law, most of it federal, that it causes the jury to speculate about why the judge isn't allowing us to see all these parts. And most people that can read well and are used to reading SOPs and directives can speculate quite a bit about what might be in there. So those are the things I'm worried about.
Understood. Thanks, Judge.
And the last thing I want to discuss is based upon the timeframes that the court was given. I took my docket back for tomorrow morning. So if we need to finish up one of these witnesses tomorrow, then it's going to have to be probably 11 o'clock and after.
So I can tell the court that my direct deputy chief is fairly short and to the point. I'm talking about 2 directives. So I think I will be done if we get started by 4 o'clock, 4:05.
All right, do we have them here? Okay. All right, well, we can, assuming that Commander Redfern's ready to go, the jurors are ready to go. Okay, our jurors are back. Well, we can be seated. All right, The court will recall the case of People v. Woodyard, 21 CR 2794. The parties and counsel are present, the jury seated. Next witness.
Thank you, Your Honor. People call Deputy Chief Redfern.
I do. Thank you. You'll be seated. Please state your name, spell your last.
Yes, my name is Stephen Redfern. Last name is Redfearn.
Your witness.
Thank you. Deputy Chief Redfern, who do you work for now?
So I currently the deputy police chief with the Boulder Police Department.
And how long have you been in that role for Boulder?
I've worked in Boulder since September of 2021.
And before you worked for Boulder, did you work at another police agency?
I did.
And can you tell the jury a little bit about where you worked and when?
Sure. So I worked for the Aurora Police Department from 1999 until 2021, at which point I left Aurora PD because I was hired as the deputy chief in Boulder.
And are you here today because you were subpoenaed?
Yes.
I'd like to talk a little bit about your educational background. Please tell the jury a little bit about where you went to college and your degrees.
Sure. So I received my bachelor's degree from, at the time it was Metro State College, Denver, in criminal justice. And then I received a graduate degree from Colorado State University in organizational leadership.
And before you went to the Aurora PD, did you have any other background in police work?
I did.
What was that?
So I started, my first role in police work was I was about 15 years old. I became a police explorer with the Arapahoe County Sheriff's Office. I did that until I was about 18. And then I became a cadet at Jefferson County Sheriff. That's a paid program where they pay college while you work part-time in the department. And then about a year later, I became a full-time 911 dispatcher at Jeffco Sheriff. And I did that until I turned 21 and went to Aurora.
And how did you begin your career at Aurora Public Police Department?
So I started in Aurora as just a basic police officer. I attended the academy at Aurora PD and then was just a patrol officer on the street initially.
And then after you, how long were you a patrol officer?
I think I worked patrol for 2 or 3 years on the night shift and then moved into a special unit.
And what was that specialty unit?
I went to the police area representative unit, which is a community policing team for Aurora PD.
And then what happened next in your career?
So, and it's a little fuzzy. I'm not going to give you exact dates, but after that, I was chosen to go to the pattern crime unit, which was a plainclothes unit that at that time mostly focused on apprehending auto thieves.
And after that, where did you go?
After that assignment, I was promoted to the rank of sergeant, and sergeant is the first line level supervisor, and I was assigned back to patrol as a shift supervisor.
And how long did you do that job?
I was a sergeant on patrol for about 2 years, and then I was selected to be the sergeant of the vice and narcotics unit for another couple of years.
And once, did you move on from being a sergeant of vice and narcotics to do something else?
I did. After that, I went back to patrol for a little while where I was a sergeant of the field training unit. So I oversaw the patrol officers who were training the new recruits out on the street.
And how long did you do that job?
I think that was about a year or so. And then I actually promoted out of that job to the rank of lieutenant.
And what did you do as a lieutenant?
So my first role as a lieutenant, I was a shift commander. Every shift has a lieutenant that oversees the entire district. There's 3 districts in Aurora. Each one has a lieutenant that runs that shift. And so I did that for about a year and then became a more administrative lieutenant within District 1 for another year.
And did you promote after that?
No, after had the more administrative lieutenant job, I was selected to be the supervisor of the major crimes homicide and major crimes unit.
And what does that entail?
So at that time, I think now there's 2 lieutenants. At that time, it was 1, and I oversaw 7 units in the investigation section. The biggest and most workload was the homicide unit. We investigated every homicide, officer-involved shooting, things like that. But I also had things like the crimes against children unit, fraud unit, special victims unit. So all of the specialized investigative teams.
Before you left Aurora PD and you went to Boulder, what was your last assignment?
So my last assignment at Aurora was the division chief of operations, which basically meant that I oversaw all of the patrol operations for Aurora PD.
And as a division chief, are you well acquainted with the directives of the department?
Yes, I was well acquainted with the directives at the time I left. They may have changed now and I'm not, but obviously up to 2021, yes.
And what are the directives? When I use that word, what does that mean?
So Aurora, each department calls them different things. Aurora refers to the policy and procedure manual as directives. It's a lot of directives that basically govern how operations should work.
And if you had to give the jury an estimate of how many pages your directive manual is, what is it?
It's extensive, probably, I know well over 1,000 pages. There's literally a directive for almost everything and every function in the agency. It's all electronic now, but I remember back when it was paper, it was pretty significant.
And how are the members of the police force brought up to date, or how do they learn about the directives?
So when I left in 2021, Aurora used a system. It's the same system we use in Boulder. It's called Power DMS, and it's an electronic program that basically takes all of the paper directive manual and puts it electronic. When a new directive comes out, it goes into your inbox as whether you're an officer, a civilian employee, and then you have to go through, read the directive, and basically sign, hit a button that says sign, and that's how you're acknowledging that you've read that particular directive.
And does Power DMS sort of ding you if you have not signed it and acknowledged it within a certain time period of when they send it to you via email?
Essentially, yes.
And if you don't do that, does someone come around or email you or call you and say, you need to look at this directive?
Yes, when you don't, when we didn't sign a directive, I can't remember the exact number of days, but after a certain time, if you didn't sign it, you would get a reminder, and then your supervisor would get a notification saying, here's all the people that need to sign their directives. And then typically your boss would come to you and go, hey, you need to get these signed off by the end of the week.
Now, we've heard quite a bit of information today about the trainings that some of the officers received at the department. How do officers use the directives versus the training? What is the relationship between the two of them?
So the directives are guidelines on day-to-day procedures. And so the officer could be trained on something, but then the directive will give them the policy surrounding whatever that is. And it's everything from emergency vehicle driving to how to take care of your equipment. There are some directives that are a must, like you shall do this. Some directives say things like you should do this. And so there's different levels of what the directive is telling you as an employee. But basically anything that we did in the department, like most departments, there will be guidelines. And so some things you don't do often, you may actually go to a directive to review and say, hey, I'm not really sure what I'm supposed to do with this issue. I'm going to review it and see what the department tells me to do.
Do all patrol officers, sergeant, lieutenants, captains, commanders have access to these directives?
Yes.
How so?
So everyone had an account in Power DMS, and you would be required to go in and sign new directives. Sometimes they would be accompanied with a test or a quiz you'd have to take. And it was just part of your normal duties. Every member of the agency had an account that you had to log in and review new policies.
Now, do these directives get revised or new directives implemented? How would officers get notice that they've been revised or new ones have been implemented?
So at the time when I left Aurora, when you would get new directives in your inbox, you would get an email, and it would say, sometimes there'd be several that get updated at once, and it would say, you have 5 new directives to review. You would click on a link and it would go to Power DMS, and then you'd review those directives.
And were there times that trainings or pre-shift meetings that sergeants or lieutenants would sit down with the patrol officers to say, these new directives came out, let's talk about them and keep them in mind?
Yes.
Why would they do that?
So there were times when a new directive that would come out was especially important. So for example, when new legislation came out that said all police officers have to wear a body camera and there's big penalties if you didn't, those are the kind of things where there would be an actual like training in the shift briefing at the beginning of shift. So everybody would understand, this is a big deal. This isn't just a updated directive on something that's not that important in the department. And so sometimes it would even come with information from our legal advisor on the law surrounding some of those things.
Did patrol officers know that directives were important and they had to follow them?
I think so, yes.
Why do you think that?
Well, when you start, obviously one of the big parts of the police academy is you have to learn every single policy, directive, and procedure at that time. And so, every time you'd go to a class as a new recruit on any subject, it would always be accompanied by, okay, and here's the policy that is relating to that subject. And so pretty much from day one, you knew, just like I would guess any business, of here's our policies and procedures. And you know that, you see people that get in trouble when they violate the policy and procedures from time to time. So, you've got to follow them, and it's just kind of it's a given.
Your Honor, at this point, the people tender Deputy Chief Redfern as an expert witness in the area of police directives, practices, and protocols.
Order or objection?
Objection, Judge.
All right, the court will, based upon the foundation, allow the witness to testify and explain relevant areas in that field.
Thank you, Your Honor. If we could please show the witness Exhibit 220. And sir, if you could please review this directive and then I'll ask you some questions about it.
Okay.
What do you recognize this document to be?
So this is the Aurora Police Directive on use of physical force.
And are you familiar with this document?
Yes.
And how so?
So this document was in place when I was with Aurora. It was updated in 2016 by Chief Metz. And so when I left Aurora, this was the policy on use of force.
And do you know whether or not, besides just this directive, were officers trained on use of force?
Yes,
And did yourself receive training on use of force?
I did.
And is this a fair and accurate copy of the directive as it was when you were working for Aurora PD?
It appears to be, yes.
Your Honor, people would ask for People's Exhibit 220 to be admitted and published.
Any objection to 220?
No objection.
220 will be admitted.
Now, sir, I'd ask you to direct you to the first paragraph, 5.3, use of physical force. And it says it's defined as the application of physical force by members of the department. Members of the department are police officers or anyone in the department.
So this doesn't specifically say police officers. It says members. I suppose generally people using force were sworn police officers, but this doesn't differentiate.
With the interpretation of members, would the police officers know that they were a member of the department?
Yes.
And it goes on to say that members will only use reasonable and appropriate force. What does that mean?
So for me, reasonable and appropriate force it's broad, but it also is situational. And so this direction from the department is basically saying that.
I'm going to object. Is this a general opinion or is this specifically related to Mr. Woodyard? Because I could see objections coming down the road with my line of questioning.
It's a general overview, Judge.
I would object to that then.
All right. Based upon the endorsement or the qualifications that the witness is the court's allowing him to testify, and the court will sustain that objection.
Is this a directive that all members of the department have to follow?
Yes,
And are they giving training on this?
yes.
Now, do you also have a directive that talks about de-escalation?
Aurora did when I left, yes.
And if you look down on the second full sentence, excuse me, the third full sentence, does it address that?
It does, yes.
Does the sentence read, when practical, officers will attempt to de-escalate their use of force and/or the situation? Did I read that correctly?
You did.
Was something about de-escalation, was that something that was important to Aurora PD?
Objection, Judge. Relevance?
I think it goes to the mens rea of these charges that we're pursuing.
All right, I'll allow rephrase, but I think it's in a directive that presumably it's considered important. Go ahead.
When you think back your time in the culture of Aurora PD, was it important to attempt to escalate before force was used against a person in the community?
I would say yes.
And when you read the word practical, what does that mean?
So I interpret that as basically saying and maybe acknowledging that in not all scenarios de-escalation is possible. So to me, reading that, it's when you're able to de-escalate, you will attempt to do so.
And in what position will an officer look for in order to see if they can de-escalate?
Can you repeat that? I'm sorry.
Let me object to this. This is improper. Is this related to Mr. Woodyard or general?
Response.
Judge, I believe it's related to Mr. Woodyard in a general way because it goes towards his knowledge and the mens rea of these crimes that we're pursuing.
All right. Well, the court would find that this witness's interpretation isn't really probative to that, so the objection is sustained.
This concept of de-escalation, how was that communicated down the ranks?
So we received training at different parts, different times on de-escalation.
And how did you and the senior leadership try to set the expectations for this?
So it was something that every time, maybe not every time, but the majority of the time when we would have training on arrest control and defensive tactics and those things, I remember the last few years we would typically have the academy talk about de-escalation as part of that training. And so I know that, there were different trainings we would send people to, things like that.
And would there often be bulletins or additional information about how important de-escalation was for the department?
Sometimes, yes.
In your view, based on your experience with the department and your leadership in the department, does de-escalation help with the community understanding what police are doing and why they're doing it?
Judge, objection as to his view and the relevance.
Sustained.
In one moment, Your Honor.
Yes.
Does your department train on why de-escalation can be helpful for the community to understand what police officers are doing in the community?
Sorry, Judge, objection. He's not an expert in training.
Sustained.
Are there benefits for using de-escalation skills when you're out there as a patrol officer?
Objection, Judge. In terms of his opinion on benefits, it's irrelevant for purposes of this case.
Sustained.
In your opinion, for a patrol officer, is it important to understand the goals of de-escalation?
Objection, Judge.
I'll allow that one.
So for a patrol officer, I think understanding de-escalation is important, yes.
Why is that important?
When appropriate, de-escalation is it can be beneficial for everybody involved in the situation. It's at its core, in my opinion, a valid thing that can help, again, when appropriate, given the circumstances.
Can de-escalation promote voluntary compliance?
At times, yes.
Speculation?
Response.
Based on his training and experience, I believe this witness can talk about whether or not de-escalation does promote voluntary compliance.
I'd object to relevance.
All right. Remind me what the witness is qualified for.
Protocols, directives, and police training.
I'm sorry, I
Hold
don't think he is.
That wasn't one of them, I don't think.
We go back, Judge, sorry. Policies, directives, and protocols, Your Honor.
All right. Yeah, the court will find that's beyond the scope.
Just give me one moment. I'm getting back there. Do you believe that if a patrol officer slows down at an encounter with a citizen, that it can help or promote de-escalation?
Objection, Judge. Relevance as to his opinion and beliefs.
I believe it goes to knowledge and the mens rea in this case, Your Honor.
Sustained.
Based on your training and experience, do you think it's important for a patrol officer to give a contacted person options?
Objection, Judge. His opinion on this is not relevant to Mr. Woodyard.
Response.
Based on his training and experience, it will help prove the mens rea in this case.
Sustained.
Are there times per your directive that no force or lesser force can be used?
Yes, I believe in this paragraph, it addresses that in the next sentence after the highlight.
And I don't want to mislead, sir. So what does it say? When practical, officers will attempt to de-escalate their use of force and/or the situation so that lesser force or possibly no force is required. Did I read that correctly?
Yes.
Can you tell the jury what that means for police officers?
So this directive is, when discussing de-escalation, again, saying when it's possible to de-escalate, the goal of that is to potentially use less force or no force at all.
And is that important in your opinion?
Response.
It goes towards knowledge of the police officers and the mens rea in this case.
All right, it goes to the witness's mens rea. So the objection is sustained.
If you go down in that directive and you look at 5.3.2, is there also a directive about rendering aid?
Yes.
And what was that directive about?
Essentially indicating that when Aurora police officer uses force, that they will make sure that the subject whom the force was used on receives timely medical treatment.
Are there any exceptions to that?
It does say that there is an exception if the member is unable to do that, if for whatever reason they're unable to render or call for aid.
Does it specifically say when the officer is physically unable?
Yes.
What does that mean to be physically unable?
Objection, Judge. His opinion on this does not reflect on Mr. Woodyard's relevance.
Response.
Goes towards the understanding that patrol officers would have when they are unable to render aid. And is it physical or is it mental?
All right, the objection is sustained.
What is important for the line officers to understand about this directive?
Objection, Judge. Unless if this is communicated to Mr. Woodyard, there is no relevance. We object relevance.
Response.
I can lay that foundation, Judge.
Okay, I'll sustain the objection at this time, subject to foundation.
How would these directives be communicated to patrol officers?
So at the time I left, again, these would have been communicated through the Power DMS program.
And once again, going back to what we initially talked about, does Aurora PD know when officers get these directives and click on them, suggesting or saying, I have read them?
Yes, so when an employee hits the sign button, a log is kept to show that on this date and time, the person signed that particular directive.
And would you send out this directive if it was not important for the patrol officers out there on the streets to know this?
Objection, Judge. Relevance?
I'll allow that one.
So yeah, I mean, in my opinion, if we send out a directive, there's a reason for that. It could be a multitude of reasons. Some of the directives are done because of accreditation purposes, but I guess it's assumed that when one is sent out, that it needs to be read.
And followed.
Yes.
Could we please show the witness 219? Sir, if you could read this, and we'll talk about it in just a few moments.
I'm good.
Do you recognize this directive?
I do.
And what do you recognize it as?
Similar to the last one, this was a directive that was in place when I left APD. It's the directive on less lethal devices, weapons, and techniques.
And as you scroll through, this is a several page document. So if you don't mind just taking a few moments and look at it, it is 9 pages. Can you tell me after you review it if it's fair and accurate to the policy that you had before you left the department?
Sure. It does appear to be fair and accurate.
Your Honor, people would ask to admit 219 and to publish to the jury.
Or dire or objection?
Objection, Judge.
219 will be admitted.
And I just want to go to the top of the directive and look at the effective date and the revised date. When was this directive effective?
September 1st of 98,
And when was it revised?
June 10th of 2019.
Now, you talked a little bit about when patrol officers would be shown revised directives. So this would come to a patrol officer in what way?
So same, this would come in Power DMS as well.
And then they would click off the box and indicate that they have read it.
That's what they were supposed to do, yes.
Is this the type of directive that if the patrol officer had not done that, that someone in their chain of command would ding them about?
Definitely, I mean, any of the directives, not just this one, but yes, this would be included in the directives that if it wasn't signed, the supervisor would get notified.
I'm going to direct your attention to 5.8.3. It's on the second page, sir.
Okay.
And what is this a directive about?
This addresses the carotid control hold.
Why would you have a directive about the carotid control hold?
Objection, Judge. Relevance?
I'll allow it.
So at the time I left Aurora, the carotid control hold was a maneuver that was trained. All sworn officers were trained on it. And so because of that, obviously, we needed a directive on its use.
When you were at Aurora PD, was the carotid control hold seen as a less lethal hold?
Yes.
And are you aware whether or not in the training they discussed the risk involved?
Yes, they did.
How was that communicated? How was this directive communicated to patrol officers boots on the ground, how did they know about this directive?
So aside from what I talked about of having to sign off on this particular directive, I don't remember the interval, but it seemed like probably once a year, we would have to go through actual physical training on the application of the carotid control hold like we would on other arrest control maneuvers. And so that was always discussed in the training.
Thank you. I have no further questions.
Cross-examination.
Thank you, Judge. Good afternoon, sir.
Good afternoon.
Your Honor, may we have control of the screen? Can we show this witness and this witness only 1.4 labeled as Defendant's Exhibit B as in boy? .04, I apologize. Deputy Chief Redfern, I want to talk to you about the hierarchy of the Aurora Police Department. Does this directive, and please take a moment to scroll through, do you recognize this directive, first of all?
Response.
Judge, this goes towards his directives. He's an expert in police policies, directives, and protocols, and I'm asking about the hierarchy and as well as the directives that were given to Mr. Woodyard.
All right, does somebody have a paper copy?
I do. May I approach, Your Honor?
Yes.
And I've given the people a copy as well.
All right, the court's had an opportunity to take a look at it. If council wishes to approach. All right, based upon the discussion at the bench, the court will allow it for the limited purpose for which it is offered.
Thank you. Do you recognize this directive, Deputy Chief?
Yes,
Okay, is it a fair and accurate representation of the directive in place when you had left APD?
yes,
Okay. At this point in time, defense moves to admit defendant's exhibit B as in boy.
All right, further objection other than that has been placed on the record. Okay, again, for the limited purpose, it's admitted.
Thank you. And may we publish page 4 of exhibit B as in boy? That'd be directive and focusing on directive 1.47. Does this state that the sergeants are supervisors with the authority to take all necessary action consistent with the directives?
yes,
Does it also state that they are the supervisors over their quote unquote subordinates?
it does.
Does it also direct the sergeants that sergeants are to assume all authority, duties, and responsibilities of their rank, and in terms of exacting the proper performance of police duties for, again, the individuals under their supervision? Paraphrasing.
Yes,
If we can scroll down to 1.411. Does this require, or excuse me, 1 second. If we can go back up to the top of that page. And let's just look at what that directive talks about. So go to the next page, 1.49. There we go. This is regarding the duties of an officer. Is that right?
yes,
Okay. And so directing your attention to the responsibility portion at the last sentence, does it require the officers to hold themselves in readiness at all times to answer the calls and obey the orders of their superior officers?
it does.
Under this directive, does it state that the supervisors are their superior officer? Or I guess if you read the directive as a whole, as a sergeant, a supervisor of an officer.
I think if I understand your question, you're asking if a sergeant is a supervisor of an officer?
Yes.
Yes, typically direct supervisor.
Thank you. Now, if we go down to 1.411, terms of the supervisor responsibility, their accountability for the performance of their subordinates being their officers, is that accurate?
I guess it depends on the rank, but if we're talking about police officer, then yes, the sergeant would be, the officer would be their subordinate.
That's a fair point. If we're talking about sergeant, we're talking about the subordinate being the officer, correct?
Yes,
I'm sorry, I trailed off. It's late in the day. I'll try to get through this. If we're talking about a sergeant and officers are subordinate, is that fair?
yes,
Okay. And in terms of 1.411, does this essentially dictate that because officers are required to obey all orders of a sergeant will be held accountable for their performance of their assigned officers?
essentially, yes.
We could just show the witness only. What I'm labeling as defendant's exhibit C, that would be 14.1.
All right, I suppose I need to see it.
I may approach her.
Yes.
Can I'm just gonna approach with all. Bless you.
All right. Got to see him.
Sorry about that, Deputy Chief. Back to what we were saying, in terms of the 14.11, here we go. Do you recognize this directive?
Yes,
Is this a fair and accurate directive that was in place when you left Aurora Police Department?
yes,
At this point in time, defense will move to admit defendant's Exhibit C.
All right, subject to the court's orders at the bench, the court will allow the admission of Exhibit C, particularly 14.1.1.
Thank you. May we publish?
May?
And focusing in on the last paragraph of 14 point, or excuse me, starting off on the first sentence, does it state any lawful order given by a supervisor officer must be obeyed?
it does.
In terms of the first sentence in the second paragraph, does it state as a directive, it is presumed that the highest ranking officer on scene is in the best position to direct personnel and tactics during an emergency call?
It does.
Take that down, please. If I could have 1 second, Judge.
Yes.
Thank you, Deputy Chief. Those are all my questions.
Redirect.
Good afternoon again.
Good afternoon.
This directive 14.1.1 about lawful orders, it says it is presumed. What is that word? It is presumed? Are there exceptions to that the highest ranking officer on scene is in the best position to direct personnel?
So based on how that is read, yes, there would be exceptions. It's not I don't interpret that as a firm always. By the word presume is,
Your Honor, in terms of his relevance and his interpretation.
All right, I'll allow some brief explanation.
I was just going to say that the reason that I think the word presume is there based on my knowledge of the directive is because it's the reason we have rank, there's supervisors at different levels. So based on their rank, it's presumed that they will be in charge of a scene, but it's not always the case.
Thank you. I have nothing further.
All right, may the witness be excused?
Yes, sir.
All right, the witness may step down.
Thank you.
All right, are we done with our witnesses for today?
Yes, sir.
All right. All right, folks on the jury, it appears that we don't have any witnesses available for the half an hour or so that we have left. I want to add to that I think as you've seen to a certain extent anyway, in particular with out-of-state witnesses and such, that sometimes it's really difficult to coordinate how long a certain witness is going to take on the witness stand and things of that nature. The reason I'm telling you about this is there's a witness who is scheduled to fly in. I believe he'll be available on Friday. Am I correct? But that's when his flight is scheduled. So with that, I guess and I'm not, just so I'm clear, I'm not blaming anybody for this. It's just something that happens in trials. Perhaps to your benefit in that there's no reason for you folks to come in tomorrow. but I will need you here on Friday morning. Please keep in mind, and I'm not sure if I told folks this account earlier, but I do recall a few years ago, I read about a big high-profile case out in the East Coast with a rather wealthy individual who was involved. And the judge gave the same instructions I've given to you now countless times. After the trial, it was discovered that it was a pretty long trial, but the jurors had become pretty good friends with one another and were texting each other about the case to the tune of 7,000 texts. Well, as you might guess, that trial had to be done over again. I don't want that to happen. So don't form or express any opinions, discuss the case even amongst yourselves, do no independent research, and stay away from any press coverage about this case, related cases, or cases of this nature. Hopefully you'll be able to catch up on a few things that you've been missing out on during your jury service, and I'd like to have you back Friday morning, pretty close to 8:30. With that, I'll excuse you. I hope you have a good evening as well as a good day tomorrow. Okay, our jurors have stepped out. Things we should discuss this afternoon?
Just schedule wise, Your Honor. The only witness that the people intend to call before we arrest on Friday is Dr. Mitchell. I anticipate his testimony will take between half and 2/3 of a day. So we could potentially resolve any halftime motions if there are any, or Curtis advisements, something like that on Friday. What I don't know is what the defense is anticipating for their case next week. And I think that that sort of affects whether we want to try and get some things done tomorrow, like addressing some jury instructions or anything like that. We are certainly available all day tomorrow. So if there's productive use of the time, or if we don't need it because next week we'll have plenty, then that's fine too.
All right, anything else?
Here's what we can tell the court as it concerns scheduling. And we talked to the people about this. As I understand from Mr. Ho, we have,
Can you pull one of the mics a little closer?
yes, thank you, Your Honor. We have one witness who would only be able to testify next Thursday. So we're trying to figure out how best to bridge that gap, with the idea being that we are ahead of schedule as far as we had planned. This witness could conceivably be available Friday, but because we have reserved Friday to accommodate the prosecution witness, I don't think we'll be able to put that witness on as well. And then it would be very, very cumbersome with the availability not being until the following Thursday. So what we are thinking about is asking the court to consider giving us the same courtesy with a break on Monday. We will endeavor to use Tuesday and Wednesday, either for, we could use those days for other potential testimony, although we're not committed to that at this point. But we would also have time to do jury instructions next week. But I just wanted to put that on the court's radar, that we may be concluding our case next Thursday. In fact, I think we would plan to.
All right. And you folks knew who this is. I have no idea. Who's the Thursday person?
This is an expert witness who would be flying in from out of state.
All right, I think I know the answer, but I'm not going to go ahead and ask it anyway.
Fair enough.
Has there been any discussion whatsoever about remote testimony of the witness?
There has not been, and I think that there would still be an availability issue.
Oh, okay, so it wouldn't matter, huh?
That's our understanding because of work schedules.
Okay. Anything that people have to let me know about concerning those issues?
And judge from the context and content of prior communications, I am assuming that the witness they're talking about on Thursday is Dr. Tarashenko. I have very significant doubts about whether she has any admissible testimony in this case. We have not received any disclosure from the defense about what opinion they intend to elicit from her. And the expert opinions that we have previously disclosed related to the paramedic case are sort of at best tangentially relevant to this case. So if we're going to end up delaying the trial schedule for a witness who I don't think has any relevant testimony, I think it would make sense for us to address that issue ahead of time rather than delay the rest of the trial based upon testimony that might or might not happen.
All right, I'll be, I guess what else would say is I have perused the opinion letter, whatever it is that that particular witness produced, but I wasn't reading it in the context that it was just discussed. So I will read it carefully and highlight things I think are important or controversial, and perhaps we can discuss that later. But it does sound, in any event, that we'll probably have time to talk about instructions later, if nothing else, Monday. Okay. All right, well, I'll read the Tarashenko stuff and we'll talk about it once I understand it.
And I'll just briefly tell the court it's highly exculpatory. So we can discuss it further, but I can frame it that way.
Yeah, I figured, I figured there would be a argument of that nature, but I kind of need to read it to get some context.
But in terms of a housekeeping matter, for Defendant's Exhibit C, I don't have a redacted copy. Is it okay if the court will reconvene on Friday that I bring a redacted copy and submit it as evidence?
Yeah, I think, the way I do it is I put it on unwritten copy. It seems to work pretty well.
I'll be able to do it before this will happen.
All right, that's fine. Yeah, that's fine if we get that taken care of on Friday.
Thank you.
All right, thank you.